Thank you, and over to you, Julia.
Awesome. So first of all, I'll just start off by, introducing my role and community law for those who aren't really familiar with our services and how we operate. So like Julie has said, my name's Julia. I am one of the legal educators here. I have been in this role for about 4 years now. So my role is to mainly go out into the community and pretty much just advertise community law and also give legal information on different areas of law that would be of an interest to certain groups and communities. So Community Law Canterbury, we offer free legal help to anyone in the community that requires assistance with, I guess, the legal system. We offer mainly one-off initial advice, but in some certain situations, we can provide ongoing assistance or representation. Our biggest area of law that we practice in is family law. We've got a good team here who predominantly do just family law related matters. But aside from that, we can advise on employment, consumer, tenancy, debt, neighbour disputes, anything like that. So for those who couldn't be here today, so if they, once they're listening to the recordings, if they are ever in need of some legal advice, feel free to give us a call and to make an appointment, or they can just give us a call and we can give them some legal information. And also throughout this, for those who are here, just feel free to ask any questions. I didn't know how many people were attending, so I didn't know, how to structure this session, this workshop. But if I have not answered anything, you can ask Julie, and Julie, you can pass on my details, and I'm happy to, communicate one-on-one or set them up with an appointment. And so on. So particularly because we're talking about welfare guardianship, we have helped clients in the past with their welfare guardianship application. We understand that sometimes it can get quite expensive. The application itself, there's no filing fee, but however, if you do go through a lawyer, I have been told that some lawyers charge up to $3,000 for an application. And that can get quite expensive if you're having to renew the order. So yeah, so feel free to get in contact with us. But I think the first application is always the most difficult one because it's quite lengthy and it's quite repetitive. So once we help with the first application, most clients are able to just kind of refer back to the original application and just, is able to do it on their own going forward. But yeah, so just get in contact with us. We're happy to assist in any shape or form. Cool. So I have just been given the rough brief guideline as to that you just want to know information about the welfare guardianship and enduring power of attorney. So the way I like to explain it is enduring power of attorney is available for people who have the legal capacity to actually to create an order. So what that means is that so as soon as someone turns 18, because guardianship rights are only up until the person is 18, there's no other person who's able to make a decision for another individual after their 18th birthday. So if they're able to make a enduring power of attorney order, then they can do so by going to a lawyer who's able to draft one up and they can get the order in place. However, if that is not available due to a number of reasons, one being if they were born with with a disability that prevents them from from having the legal capacity, then unfortunately enduring power of attorney is not an option, and that is where the guardian or the parent would have to apply to the family court for a welfare guardianship order. And I'm sure that Yolanda will be able to explain all the family court process. So I'm not going to go into too much detail because I'm going to leave that up to the expert with you later on. But yeah, so that's kind of the biggest thing that a lot of people get confused when clients come and see us. They say, okay, we want to create an enduring power of attorney, but then they don't understand that it's not available for people who do not have the legal capacity. And that is why the welfare guardianship is in place and it's there for people. And also certain situations where you have the legal capacity, but you were in a car accident and you don't have an enduring power of attorney pre-set up, but a parent or another family member would have to make decisions for a short period of time. That's also a situation where welfare guardianship application can be made. Because a few years ago, we had a situation where someone was in a coma and that person was over 18, didn't have any orders in place, didn't have an enduring power of attorney. So we had to put in an order for so the parent could access some of the bank accounts and things like that on behalf. So the welfare guardianship, just to give a brief overview. So a welfare guardianship guardian is a person appointed by the family court to look after the welfare of a person who is completely unable to communicate or understand decisions about their personal care and welfare. So the court will appoint one person as a welfare guardian. The person must be an individual, not an organisation, and must be at least 20 years old. The court will not appoint someone to be a welfare guardian unless they're satisfied that the proposed appointee is capable of carrying out the role satisfactorily, taking into account the person's needs and relationship with the proposed appointee, and will act in the person's best interests, and also is unlikely to have a conflict of interest with the person the application is made about, and consents to the appointment. So before appointing a guardian, the court will, as far as is practical, find out who the person wants to be appointed as welfare guardian. The powers and duties of a welfare guardian, so they have quite wide range of powers, enabling them to do everything that's reasonably necessary to make and carry out decisions for a person. However, they can only deal with the issues specified by the court in the order appointing them. Typically, the welfare guardian is responsible for making decisions about where a person lives, the arrangements for a person's care, including the carers, and what medical treatment or therapy a person might receive. So the welfare guardian must always promote and protect the person's welfare and in their best interest. The welfare guardian must always seek to encourage the person to exercise their own capacity and to encourage the person to be self-reliant, and to help the person to be part of their community as much as possible. So as a welfare guardian, you should not be, I guess, isolating that person or removing that person from a certain community. So the biggest, I think, it comes down to is the most important, the best interest for the person that you are making or taking out an order for. A welfare guardian must consult as far as practical as well, with a person and also with any other interested people. And this could be the hospital caregivers and any property managers appointed under the Act as well. So not necessarily that they will have to listen and take into account all the family members or the whānaus that's involved, but however, if they, if they want to just determine what is in the best interest for that particular person, then obviously looking into the wider, I guess, the close network around the individual is always quite helpful in determining what is necessary and what is required. There are limits on the welfare guardian's powers. So the welfare guardian does not have the power to make decisions for the person about entering into or dissolving a marriage or civil union. So they don't have that power. They can't make decisions about adoption or any of the person's children. Refuse consent to standard or life-saving medical treatment. Consent to brain surgery or brain treatment for the purpose of changing the person's behavior. Consent to medical experimentation unless it is intended to save the person's life or prevent serious damage to their health. There are safeguards to stop a welfare guardian from abusing their powers, and some of that is the family court can specify the areas, or they must specify the areas of life about which the welfare guardian can make decisions about. The welfare guardian is not paid for their service, so there is no financial motive to be appointed. However, their expenses can be met. A welfare guardian can be personally liable if they act in bad faith or without reasonable care. They will also be personally liable for contracts or other arrangements that they enter into. So, for example, like a mortgage, if they fail to disclose that they are acting as a welfare guardian. An application can be made at any time to the family court to review the decisions of a welfare guardian as well. So if a family member has concerns, then they can apply. The personal order must be reviewed within 3 years and can be reviewed earlier on application. And as a result of a review, a new guardian can be appointed in the place of an unsatisfactory welfare guardian. Interesting. Okay.
Yeah. You just saw that question come up, Julia. Is that why you're saying interesting?
I did.
Yeah. Okay. So the question, just for everybody there, is how does consent to re-COVID vaccine work, re-welfare guardianship?
That's a really good question. It will come. So it is coming down to because it is a medical treatment. Getting vaccinated and such. So I think it will. Don't quote me on this, but I think it will all come down to the best interest and the individual themselves, from upon getting maybe medical expert advice on the particular individual, whether it is something that they can get, or if they are unable to get due to whatever health conditions that they have or they may have. I haven't really looked into the COVID related for the welfare guardianship, unfortunately, so I don't have a definitive answer on that. But I'll make a note so then I can see if there's some information around that, if that's something that people might be of an interest, and then I can flick that through to you, Julie, if you want to circulate that, because I think that is a really good question, and unfortunately I have not looked into it.
That's great, thank you.
Yeah. So the other question, another common question that I get is, does wealthy guardian get reimbursed for their expenses? And the answer to this is that all reasonable expenses incurred by a wealthy guardian can be paid for out of the property of the person for whom the wealthy guardian is acting. If there is not enough money available to pay the wealthy guardian reasonable expenses, the wealthy guardian can be reimbursed from consolidated accounts, so Parliament's bank account. How long does a wealthy guardianship last? So the court order should specify a date by which the wealthy guardian is required to apply to the court for a review of the order. The date must be no later than 3 years from the date of the order, but it is recommended that the wealthy guardian start the application process for the review at least 3 months before the order expires. So there's no, so it doesn't lapse. Because we have had situations where the client has left it and the order is expired and they haven't done anything about it, and therefore they don't have any, I guess, court-appointed orders or right to act for that particular individual. So that's just another common thing that we see, is that just reminding people that, yeah, so if it's coming up for review, just think about, you know, making sure that you get the application in order, you know, in the in the family court for them to go through, and I'm sure that Yolanda will be able to explain or maybe give some sort of guidance as to the process and the length of time that it might usually take for one of these things to go through. Because I've only heard it through the experiences that our solicitors have dealt with, and you know, and it does range from some orders get made real quickly, and some orders it takes about 6 to 8 months for welfare guardianship. And we've had a situation where, unfortunately, the individual had passed away before an order was made. You know, so there are obviously multiple situations that that would kick in, but with COVID and everything, and I know how busy the family court is. So, you know, with everything and a lot of the workload, it might mean that the order is not made as quick as possible. But in saying that, if there is a urgent need for an order to be granted, this needs to be clearly outlined in the application. So you will need to state the reason for why the application requires urgency, and it may be helpful to get medical professional to also comment on the urgency of the application as well. It may be worthwhile letting the registrar at the time of filing that there is some urgency to the order. And like I said in the beginning, there's no filing fee for either the wealthy guardian or the property management or applications. But however, if you do hire a lawyer to complete the application for you, there will be a fee for that. There is legal aid available to those who qualify for this. You may want to make inquiries as to whether you are eligible for legal aid before making the application itself. And also, if you do qualify and you're struggling to find some legal aid providers, you can always call us into reception, and we've got a list of legal aid family lawyers in our office who may be able to help, and we can give some referrals. But I do know that also other family lawyers are quite busy, and capacity is always quite an issue. So it is something that you know, people will just have to call up and just inquire whether the firm or the lawyers have capacity to take on a welfare guardianship application, and they will give they would give some guidance around that.
Quick question, Julia. Is there anybody that cannot be a guardian?
Cannot be a guardian. So in order to be a guardian, you just have to be at least 20. And I guess you just have to kind of somehow show the relationship as well with the individual, that whether that is just establishing, you know, how you particularly know this person, because we've had a situation where they weren't a blood related member, but they've been in there like their entire life as an aunt, you know, so we just had to outline the relationship between the individual and why this person is the best person. And also when you are applying and there's other family members, it's always good to get consent from the other family members as to why this particular person who's applying is the best person. So then the other family members, you know, isn't, I guess, objecting to the appointment of a welfare guardian. But like I said, there's, you know, but there is room for there to be, for them to, I guess, reject, you know, or kind of, yeah. But other than that, it's just, it's up to the end of, it's up to the person. Another thing that we've also been noticing is that people ask that, well, people tell me that they don't have any family members or friends who's able to, I guess, apply. In that situation, there are some individuals out there who actually do it for as a professional service. But obviously with that, there will be a fee, there will be a service fee for that. But it honestly can be anyone. You know, it doesn't necessarily have to be a family member, if that makes sense. Yeah. Does anyone have any other questions?
Hi, Penny here. Just wondering how much investigation goes into ensuring that the person is appropriate to be a welfare guardian or has the individual's best interests at heart?
Perfect. Okay, so okay. So once an application is made, the court will appoint a lawyer for subject person. So what that is that it's just a lawyer who's able to, or who should meet with the individual and determine and give their, I guess, they'll have to make a report on their findings, pretty much, and give the information back to the court to say. So that person is a lawyer acting for the individual. So, and then they will also meet with the person who's applying as well, and that so that's kind of part of the investigation, as to determine whether the person who's applied is best fit during their, I guess, meeting or interview, like you call it. So the lawyer for subject person will make or will determine, you know, that the person who's applying, because the individual is unable to express their own views, you know, because the whole point of making an application for a welfare guardianship is because that the individual themselves are unable to, you know, express their own personal views on the matter. So the lawyer for subject person is an experienced family lawyer who have been in the business for a really long time. So they will make the call, you know, and then they will give their own professional, I guess, guidance as to, yeah, I've met with the parties, and yeah, it really depends on who the lawyer is, and, you know, how thorough the investigation is, and what they report on. But unfortunately, the answer to that is that it depends on the application.
Cool, thank you.
No worries.
Are there any other questions for Julia at all?
I guess we can come back after Yolanda talks about the family court process, and if other questions pop up, you know, they can always ask at the end.
That's great. Thank you, Julia. Hello, Yolanda.
Hello again. Okay, so from my side, thanks very much, Julia, for that. It was really good information. So it was also good for me to hear that as well. And I'll just build really on what Julia's already said. So applications do come to the family court. There's a couple of different ways that those applications can come to us. You can make the application, you can email it through, but we do need to have originals of the application. You can bring it in to us, so at the counter, customer service area. So the Christchurch Court is located on Durham Street, on the corner of Durham and Litchfield in Chewham, big building, can't miss it. We also can accept them by mail as well, so you can mail the application in. We will, of course, check the application to make sure that everything is filled in correct. So what I mean by that is that the applications, as Julia said, they're really long forms. You're repeating, as the applicant, you'll be repeating your name at least 5 times on the form and repeating the subject person's name 5 times on the form. So we know that they're not the best forms. They are what they are, unfortunately, so we do have to work with what we've got. So we will check the forms. If there's something not quite right, we'll give you a call and we'll just talk through what else we need, what more information, maybe if something's not quite right or not clear, we'll talk to you about that and talk you through that process. So in terms of the applications that commonly get filed, so Julia talked about Welfare Guardian quite a lot. There are other applications that we can also get. So Welfare Guardian is one of them, and that looks after obviously the welfare of that person. We can also have property managers, and they look after the money or asset side for that person. And there's also personal orders. Personal orders are very specific, and they are there for a very specific reason. For example, living arrangements. So if the subject person needs to go into a medical centre for treatment, then you may get a personal order to do that. Or if they need to be placed from hospital into a home, then again, you could apply for a personal order for that. And there's a number of other situations. A specific medical procedure, for example, maybe a personal order is more appropriate. Now, I don't have any legal qualification like Julia, so I can't comment on what the best orders are, and that's not our role at the court. All we really do is the administrative processes and tasks associated with the application, and just make sure that it's filed correctly, and we I suppose help you along the journey of going through the court. In terms of the applications as well, so there's a couple of ways that you can file applications. Under the PPPR Act, which is what these applications are, you can't file urgent applications. Now, when I say that, there's a particular term called without notice. You can't, so if you're familiar with that term, you can't do that for these applications. What you can do is you can apply for interim orders. So part of the forms, well, at the very end of the application forms, there is an area where it asks if you need interim orders. You could have an interim welfare guardian or an interim property manager. What those orders might include is because the process for the court can take 1 or 2 months. Julia mentioned 6 months. Unfortunately, sometimes it can take a bit longer. If you need an order more urgently than that, because you need to be able to agree to a medical procedure, or they need to go into a home, or something else of an urgent nature, not just because you want the order quickly, that's probably not considered urgent, but for other instances, you can also fill in that extra little bit that talks about interim orders, and then explain to the court, explain to the judge why you need an interim order. Interim orders generally last for 3 months, but they can be extended. So, but the ideal would be is that within that 3 months, you're able to do whatever you needed to do urgently, and then you can get more final orders a little bit further down the track once some more investigation has happened, as per what Penny's question was. So in terms of timeframes, I also agree with Julia that starting the process 3 months earlier than when it would expire is a good idea, because like we said, the forms are not great. So it's good to give yourself some time just to get refamiliarize yourself with the forms. You may be realistically doing this every 3 years for the subject person's life, for example. When we talk about the 3 years time frame as well, 3 years is the most common. In exceptional circumstances, it could be longer than that. I can't talk about what those circumstances would be because they're very individualized, but generally 3 years is it. So do get onto that process within that 3 months. It is a good idea and a good practice to have. When you file the application, what we will always do is we will appoint a lawyer, as Julia said. We'll appoint a lawyer, and that lawyer is an experienced lawyer that has done these applications before. They are aware of the obligations, what they need to do. They will meet with the applicant, who is the person applying for the order. They will meet with the subject person being the person who needs the order, and they will meet with anybody else who maybe has an important part in the subject person's life. So maybe if they were married before an accident, or if they have siblings maybe, or if they have both parents, they will meet with all of those people to determine that yes, the welfare guardian is the best person for the job, or the property manager, whichever it is. That lawyer is usually given a time frame of about 3 weeks, but to be fair, it depends on their workload. Especially this time of year, things take a bit longer. People are stressed, it's shopping, it's all that kind of stuff. So, but generally speaking, 3 weeks, we would hope that we would have the report from that lawyer for the subject person. We do have a relatively small pool of lawyers that we can choose. It's not just any lawyer. They are specifically appointed because of their experience in this particular field, so they should know what they're doing. Any complaints about that lawyer would go to the Law Society, or you can contact the court and we can talk through that process as well. So once they have done some investigations, they have looked into the person. Julie, you also mentioned that question about who can't be appointed. So also just to add to what Julia said, people that can't be appointed also include people who are under the Mental Health Act. So that's another thing to be wary of, and they can't be subject to an order themselves. So what I mean by that is they can't have a welfare guardian order on them. So they can't be a subject person and then apply to be a welfare guardian of someone else, because they obviously have that order in place for a reason, so they may lack capacity themselves. We have had that happen previously. Okay, so once the lawyer is appointed, they will file their report. You should be entitled as the applicant to get a copy of that report, so you should be able to get that. If you don't, you can contact the court and we can give you a copy of that report. That report then goes to a judge. And when I say goes to a judge, it's not a court hearing at that stage. It's a judge sitting in their office. We give them the application that's been filed, we give them the report that's been filed by the lawyer, and then a judge makes a decision. Now, the judge's decision, often, if there are no issues, the application is good, the lawyer's report is recommending that yes, this person is the best person for the job, they'll do it well, then it's likely that the judge will grant an order, whatever they are asking for, whether it's welfare guardian, property manager, or a personal order. If the lawyer's report comes back and there's some questions that need to be investigated further, there may be the requirement to come to a court hearing to talk to the judge. So the applicant would come to court, there would be an official hearing in a courtroom that would be held here on site. The subject person, though, does not normally have to come along. The only reason that a subject person might have to come along is if there might be an issue of capacity. Maybe an applicant has applied to be welfare guardian for the subject person, but the lawyer is saying, well, actually, the capacity, so the understanding to make decisions for their own welfare is actually a bit higher than what the applicant might think. So maybe the judge wants to meet the subject person. Doesn't happen often, to be fair, but yeah, so that might happen if there was some capacity question marks there for the judge. Otherwise, the judge would grant the order. The order would be typed up, signed, sealed, sent out to the applicant. The subject person doesn't get a copy of the order just because they probably wouldn't understand the contents of the order. It might be upsetting in some circumstances. We always keep a copy of the order on the file. So if you misplace the order, for example, we can definitely send you another copy of it. You could also get another copy from the lawyer that was appointed, because they will also be sent a copy of that order as well. And then you roll around to your 3 years and you do the whole process again. You do the whole process again. There's not a shortened version for reviews, for example. It's that same process of filling in the form, applying, bringing it to the court. Lawyer is appointed. We'll appoint the same lawyer the next time around as well. So we'll try and keep consistency for the subject person, use the same lawyer. The only reason that we wouldn't is if that lawyer is either maybe retired, not practicing anymore, has stopped that kind of work, that kind of thing. So generally, these kind of applications are dealt with on the papers. So they're dealt with without the need for a court hearing. Now, in some situations, there are families who can't agree on who the welfare guardian or property manager should be. So it is a situation. Sorry, Penny, I did see your question. I'll come back to that one. If the family's not agreeing, then maybe there needs to be service. Now, what service means is that as an applicant, you filed the application, then a copy of that application is given to other interested parties, usually family members, who the applicant may be aware does not agree with them being welfare guardian, or maybe they want to be welfare guardian. So the application would be given to them, a copy of that, and they get a chance to respond to that. Their response would be given again to the applicant, it would be given to the lawyer that's automatically appointed, and there would need to be a court hearing about that. Unless there was agreement, there needs to be a court hearing, and the judge would determine who's going to be a welfare guardian. There is also the circumstance where occasionally 2 welfare guardians can be appointed, but that's not the normal, and the judges would prefer generally that it's just the one person. Otherwise, you can have conflicting decisions about what is best for the subject person if you have 2 welfare guardians. Now, I will just go and have a look at the question from Penny. So, can organisations ask for a copy of the order from the courts? Good question. So they can. Whether we give that to them or not is a different story. It depends on who the organisation is, what their relevance is to the subject person. So, for example, if it is if there's a property management order in place and it's the bank, so the subject person's bank wants to have a copy of the order, yes, we probably would, because they're an interested party and they have a right to know who the property manager is and that they can make decisions on behalf of that person. If it was a medical facility, or if it was a rest home or some other facility like that, if the subject person is staying there, we could give them a copy of the order. However, our preference is that they get a copy of the order from either the applicant, who should have a copy, or from the lawyer that was appointed, because otherwise the court is in a position where maybe it's not appropriate for the organisation to have a copy of the order. So it really depends on who's asking, what the organisation is to have a copy of that. It depends. Does that answer the question okay, Penny? Cool, excellent. Okay, the last thing I was going to just talk about was the property manager statements. So if you are applying to be the property manager, so that's looking after the money and assets of a person, And I'll use the example of that Julia said, maybe someone has had an accident, like a car accident, and they've lost the capacity to make decisions for their well-being and in regards to money. So they were a business person, they had a job, they had a house, they had a car, maybe they had a boat, I don't know, but they had some assets and a bit of money there. So maybe a property manager is needed there. So someone becomes the property manager. It is then that property manager's responsibility to file statements as to what the incomings and outgoings are for the subject person's affairs. It's not just providing numbers and figures. It is a bit more detailed, and my recommendation for those statements is you can have a look on our website, Ministry of Justice, but also the Public Trust has really good statements to have a look at. They've got examples, they've got spreadsheets and Word documents that outline exactly what is needed, what you need to file. So not only numbers and figures and what the property is, but potentially valuations, rates, bills, bank statements, car insurance details. So it's all of that stuff. And the reason that I point you to the Public Trust is because they are the ones who, when you file the statement, which needs to be filed 3 monthly after the order is made, and also then annually on the anniversary of the order, and then a final statement once the order is about to expire. So that's the 3 times that you need to do those statements. Then once you file that with the court, and you do need to file it with us, we do have forms available as well, then we send that to the Public Trust and they audit that report or that statement that you filed. So they look it over, make sure that it is kosher. Unfortunately, there might be instances where there could be some financial abuse happening, and they are there just to make sure that everything is above board, everything's being done properly and correctly, and they also charge for that service. So just an awareness there that they charge for that. That's something that you can claim back from the subject person's funds. Yeah, or you could ask the court for reimbursement of that, and it would come out of Parliament or government funds as well if there was a need. But yeah, the property statements are something that we are focusing on at the moment. They need to be done correctly, and there's quite a few implications. If it isn't done correctly, you can the judge can summons you to court. They can fine. They can do some things that are not that pleasant. So it's good to get onto those statements and get some really good advice about how to do those. I think that covers off everything that I was going to talk about. So unless there's any other questions.
Thank you, Yolanda. Just a question here. So for anybody that's finding that legal system overwhelming,
yeah,
is that something that both I'm going to assume not the courts because there would be conflict of interest, but Julia, is that something that Community Law Canterbury can provide support with to complete all of those forms and help the individual go through the system?
Yes, that is something that community law can do. We have the capacity to assist clients with the welfare guardianship application, and like Yolanda said, it is a very lengthy document and very repetitive, and we tell our clients, if you're repeating yourself, you're doing it right. Because it does require a lot of, you're having to write your name at least 5 times, having to read the the individual at least 5 times. But then sometimes we assess it on whether they are able to do it and then give it to us, and we review it to see whether oh yeah, you've done it correctly, or if they really need like a step-by-step guide. And we would sometimes appoint, get one of our interns to just sit down with them, spend a few hours, and just go step by step. So it is something that we can help, and that is where anyone can get in contact with us and make an appointment, and would set aside that for completing the applications.
And then just to reiterate, Julia, and correct me if I'm wrong here, but then the fee for your service to assist someone going through that is free?
Yes.
Yeah. Okay. And so assuming that I've got all of my ducks in a row and I've got the support person from you and my child is about to turn 18 years old, what lead time into contacting you should I leave?
We would, I guess the sooner the better. So then, because then we can kind of have a look at the capacity, because we're quite busy here as well. So if you come in and only give us, let's say 2 weeks before the child turns 18, we're not going to be able to pick it up straight away. We're not going to be able to, I guess, provide that helping hand assistance. But if you give us enough time, then we can assess who's got capacity in the office. And then we can kind of work through it. So I guess if you give us at least 3 or 4 months before, because it's always good to just get in contact as soon as it's necessary and required. So then we have an understanding as to the urgency as well. Because unfortunately, we will have to take more urgent matters, and we do a lot of family law here, and protection orders, without notice ones are top of our priority at times. So it is something that we do recommend clients to get in contact. And then we can give them a bit of a time frame too. We'll be like, okay, so you've got some time. So then maybe attempt at doing the application yourself and then come back to us next week. And then we can review the forms. So it doesn't really take up a lot of our resources, but we can still assist you on the sideline, because that's most of our work as well. We kind of like ghostwrite a lot of, in the background, assisting them with, okay, so you've done this bit right in the application, but we recommend maybe, working on this bit. So the more time you give us, the better.
Has anybody got any other questions for either Julia or Yolanda? In which case, Yolanda, just a quick question for you. You check through all of the forms, etc., before it is that they then get passed. If you were to say that there were kind of 3 common things that you see where you're having to go back, are there kind of 3 that's, are there common themes that we could be aware of?
The forms are quite prescriptive. They are long, but they're prescriptive. So they're basically asking a whole bunch of questions of you to fill in. So there's not a whole lot of blank boxes that you need to fill in your own stuff. The one box, I suppose, is about the interim orders part. So if there's urgency, that is often there's not enough detail in that particular box. So if you are needing an interim order or an urgent order for some reason, explain why in there. We just need to know as much as possible, or the judge needs to know why you need the interim order. Why do you need it now? Why can't you wait another, 5 or 6 weeks potentially for that lawyer to do their report and for them to get onto it? So it would be explaining that. The other thing, and this is across the board with any legal documents, we'll find that the affidavit can often be not witnessed correctly. So part of the forms is an affidavit. So either going to community law and getting them to do it properly, so initialing all the pages, exhibiting documents that need to be exhibited, or you can come into the court to do that. I mean, we're not going to turn you away or close the door and say no, we can't help you. Of course we're going to help. We just don't probably have as much time as maybe community law has to spend with people. So there's that. And then the last thing that I would probably say is, and I didn't actually mention this, and I should have, but with the affidavits and the applications, you must provide a medical report on the subject person as well, and sometimes that does get missed too, or the medical report is 6 months old. and a judge would be asking for a more recent medical report. There's a particular form that should be filled in for that. So it's not just like a doctor's certificate, it's an actual report, and the doctor or the GP or the specialist for the subject person needs to fill that in. And it's got a whole bunch of questions about capacity, about what kind of capacity or illness, or what is preventing them from making their own decisions. So it talks all about that. So that report as well is something that either is missed, or maybe it's not as current as it could be. So if it's within 3 months, that should be okay. Ideally, it would only be up to a few weeks old, would be better. Yeah.
Awesome, thank you. Are there any other questions at all? No, okay, then I just want to say a massive thank you to Julia from Community Law Canterbury and Yolanda from the Ministry of Justice for giving up your time to come and present today. I would also like to acknowledge Allenvale School, who without working collaboratively with them then would not have been able to make this series the success that it has been. And also to the families. If there are any other information series that you would like us to run in the future, please do not hesitate to reach out to us and let us know. Thank you all so very much for your time, much appreciated. Bye-bye.
Thank you.